Okay. All right. Oh, sorry. Bye.
Bye.
Okay. All right. So now. Okay. So. All right, so let's get started. So first of all, what to do after the death of a loved one. So without, just in general, immediately, this is a time where people are really in a state of grief and a state of uncertainty about what to do next. This is a time period where family tensions can arise, over who is going to handle things, uncertainty about who's the executor, who's the beneficiary, or, lots of things do come to the surface. And until it's finalized or sort of sorted out who is to handle things, there can be a lot of confusion. And this is where we try and help you sort through that. So first of all, kind of a basic question is who is in charge? And frequently, someone who was the power of attorney during lifetime thinks that they are still able to handle things. But the power of attorney does stop on the death of that individual. So if you were power of attorney, you will not be able to access the bank accounts or pay any bills after that individual's death. Now, the power of attorney, that individual may also be appointed as the executor. But that executor doesn't have authority to act until the will has gone to probate and the executor is formally appointed. So sometimes there can be a gap, right, in between while you're waiting for the will to be probated where there is no one who has legal authority to handle anything. So generally in that time period, it's going to be family members who are going to step in and handle things, take over things. The executor can start to do some things, but will not be able to legally move any money. If there's no will, then at some point that family will have to decide who's going to apply to be the estate administrator. Now, this is where having someone joint on a bank account can be very helpful, because if you named someone joint on a bank account with you, that individual can still access the bank account after your death. That's because the account, if it's not in an individual's name alone, if it's joint with someone, that account will not get frozen. So that's why frequently parents will add their children onto a bank account to be joint with them, for a couple different reasons. And one is to help them pay bills while they're still alive, but also so that they would have immediate access to some funds after their death. And that can be important to carry over paying bills for a house or paying for the funeral. It's good to have those funds available while you're waiting for an executor to be appointed. So who should you notify? This is a question we get frequently. This is a list of, typical people that you would need to notify: close family and friends, your employer, your attorney, the funeral home, of course. Now, the funeral home takes care of notifying Social Security. So if that individual is receiving Social Security benefits, the funeral home will take care of notifying them. And then Social Security will take care of, getting a refund of any money that's due to them. They automatically debit that from the account. Now, if there's any other types of income that person was receiving, such as pension or retirement, you would have to notify those companies individually to let them know. And then generally they'll send you paperwork to fill out. There may be a refund, or there may be a small, death benefit that's owed to you. It's going to be different with each company. Banks, financial advisors. So it's important to let the banks know. And I, was just talking about how it's can be a hardship if the bank account is frozen. But on the other hand, to prevent fraud or to prevent any unnecessary charges after death, you do want to notify the banks and the credit card companies to make sure the accounts are frozen so that no one is making any transactions on that account after death. So it's important to look through the list of financial accounts and slowly begin to notify anywhere that the individual had an account. Utility companies, again, they don't have to be notified right away, but depending on whether the decedent had a home and whether you intend to sell that home, at some point the utility companies will need to be notified to change the billing address or even to be shut off. Department of Motor Vehicles. So if there's a car that was just in the decedent's name, we recommend that no one drive the car until title is transferred. And you can either, if there's a will, you can see who the car is left to and wait until you're the executor to transfer the car. Or if it's not mentioned, or more commonly, if it's the spouse or the children who are going to receive the car, you can go to the Department of Motor Vehicles with the death certificate and fill out a form there to have the title transferred over to you without having to wait for a court appointment. So that's something that's convenient to do, so that the car can be transferred, so that the spouse or the children can either put it in their own name and start driving it, or they can take care of selling the car. And until that's done, you would keep the insurance going, but once that's transferred, you would be able to switch the insurance. So these are just a few examples of some of the most common places that you would need to notify of an individual's death. So what immediate actions do you need to do? So immediately, of course, you're going to look at securing any personal belongings in the person's home. If there's, cash or jewelry or other valuables, you're going to want to secure them or remove them from the home or lock them up. You're going to want to make sure the mail gets forwarded, make sure the house is physically safe. And also you may want to take a rough inventory of the items that are in the house. Not necessary in every case, but each family situation is different. And we have many cases where there are multiple children who are the beneficiaries, and the will says that the personal items are to be split among the children as they agree. Well, not everyone agrees sometimes. So it's good to take a list of everything that's in the house and then sit down with the family and go through, so everyone has a chance to pick out items that they want. And, of course, in families where everyone gets along, that's going to be very smooth. You may not even have to do that as a formal inventory. But if it's a case where, I'd say children, it could be nieces or nephews, whoever who may be fighting over the contents of the house, then it's going to be better to make sure no one has access to it. You get a list or an inventory. Sometimes you even need to get values of everything in the house before it is distributed among all of the beneficiaries. Another way you can handle it, if people decide they don't really want anything, or if they pick out one or two things and then there's other assets that are left in the house, is to have someone come in and do an estate sale, and then the money can be split among the beneficiaries. So there's a couple of different ways to handle the personal possessions that are in the home. So next, now funeral service arrangements. So generally this should be a straightforward part, because hopefully your family knows what you would want done and what type of arrangements you would want. Some individuals go ahead and prepay their burial. They go to a funeral home and make arrangements ahead of time. So if that's been done, you just have to follow through with that. But there's also times where the family may disagree over what type of arrangements should be made. If this is something that's been planned out ahead of time, that individual can sign something called a disposition of remains appointment. And this document lets you appoint someone to make your arrangements and to specifically say what your arrangements are. And it's in writing, it's signed, and it's witnessed by 2 different witnesses. And the benefit of this is it eliminates any uncertainty as to what you want done. For an example I frequently give is if it's a second marriage and your spouse does not agree with what the children from the first marriage would want as to your funeral arrangements, right? Sometimes, the children may think that their parent wants to be, buried next to the first spouse, right? But the second spouse is thinking, no, that my husband or wife is going to be buried with me. So these are the kind of fights that it can be difficult for families to get into. So if it's discussed ahead of time, or even to the extent of doing this form where you have it in writing and signed, that helps eliminate a lot of uncertainties as to how to handle things. Another thing that people do, and it's not as common, but I do see it a lot, is they donate their body or they donate organs. Albany Medical Center has a wonderful program where if you are so inclined, you can donate your body for scientific research. Albany Med handles all the arrangements. You just have to contact them and sign an agreement with them. Another question that comes up is who pays the funeral director? So as I said before, if the accounts are frozen and there's no joint bank accounts, there's no money that's immediately available from the estate to pay for the funeral. So in that case, there's a couple of things that you can do. Some family members may be able to pay that in advance and then get reimbursed from the estate after an executor has been appointed. Other times, if no one has the funds ahead of front to the funeral home will wait until the will is probated, and they are one of the creditors who will get paid first once the estate has been opened. Or sometimes if there's life insurance, the funeral home will assist in filling out the life insurance claim forms, and then they'll receive the money first to pay off the funeral bill, and then the balance of that money will go to the other beneficiaries. So there's a couple of different ways to handle paying for the funeral, and the funeral directors are very familiar with all of these different ways of doing it, and they can help the family through this process. So once those arrangements have been done, usually this is the time next where you would set up an appointment with a lawyer. And before you meet with the lawyer, you're going to want to bring certain documents. And you're going to want to find out where the documents are. So if there is a will, you're going to want to check with the lawyer's office to see if the lawyer has the original will there in their office. For example, we keep all of our clients' original wills in our office. So so they're there, but some clients, may have wanted to take them at home, or other lawyers or law firms may handle it differently. So if it is at home, you're going to want to know, is it at home? Is it in the safe deposit box? You're going to need to locate that original will because we do need the original will to file with the court to probate. If you have your will or other documents in a safe deposit box, that can be a problem. If there's only one name on the safe deposit box and that person dies, just like the bank accounts or the credit cards, the safe deposit box is frozen and no one can get into the safe deposit box until an executor is appointed. So if that's the case, you have to wait until an executor is appointed, and then the executor can go to the bank with a copy of their appointment, and they will be able to open the safe deposit box with a bank officer. So that does happen sometimes. In order to avoid that, just like a joint bank account, you can put someone joint on your safe deposit box with you. And that will at least give that second person access to the safe deposit box in case or in the event of your death. Now, if you're looking for the will and it's not with the lawyer and it's not in the person's house, there's a possibility that the will may be in the safe deposit box, but you don't know that for sure. So there's a special proceeding that you can do with court. It's just a proceeding to open the safe deposit box to look for a will. So you get an order from the court, you go to the bank and you open the safe deposit box, the bank officer is there, and you can't take anything out except for the will. So if the will is there, they let you remove the will. You have to immediately go back and file the will with the court. And then they go ahead, have the executor appointed, and then the executor can go back to remove the other things from the box. So there can be some complications, as you can see, with a safe deposit box. generally it's going to be easier if you have the original will at the lawyer's office. So if you're the executor, you know, you may or may not have copies of the will, or you may have been given the name of the attorney's office where the will is located. So that's usually where you're going to start, is to call that attorney to see if they do have the will, and then make an appointment to come in and go over everything. So when you go to that first appointment, these are the documents that are needed, just a short list of them. So copies of any estate planning documents, such as wills or trusts, tax returns. The last tax return is a good place to start to gather information and look for different accounts if you don't know where any of the bank accounts are. So in an ideal situation, right, hopefully the information is organized, and you know, the individual has kept a list of where all their bank accounts are, where their retirement accounts are, who their life insurance policies are with. And that's in the best case, right? So then you can take that list and go through that and start to find out where things are. We have many clients like that. We have many clients, on the other hand, who didn't make a list, and their family comes in and they're, you know, bewildered, and they don't know where anything is, and they come in with a box or a shopping bag full of documents. And sometimes we have to go through this and kind of hunt out and see where things are. So the goal is basically to get a list of where all the banks are, if there's life insurance, if there's retirement plans, any deeds for any real estate, and to start to gather a list of bills that need to be paid, so that you're ready to pay them once the estate is open. So to start the legal process, before you can do anything, you do have to go through probate. So if there was a will, that's called a probate process, and you're going to file the will with the court and ask to have the executor appointed. If there's no will, then you're filing something called an estate administration proceeding. And with no will, the estate administrator can be one of the next of kin, like the spouse or the children or the next the relatives. And one of them gets to file and be appointed as the administrator. And you need either an executor or an administrator to be able to handle the estate. So the probate process, so I get the question, if I have a will and it names an executor, why do I have to go through the probate process? So the probate process is giving the court a chance to say that the will is valid and that the provisions of the will be followed. So you're asking the court to say that the will is valid and to approve the appointment of the executor. All probated wills are public record. So if there's a will filed, anyone could see it. So that's just, you know, it doesn't really matter to most people, but it is something to keep in mind when we talk about probate and wills. So a probate is only for property that's in the individual's own name. So if I had a bank account that was in my name that wasn't joint with my husband, that would have to go to probate. However, if I have joint assets, for example, a joint bank account with my husband, on my death, that goes automatically to him. That's not part of the probate process. You know, our house, because that's in joint ownership, that would go to him and not be subject to probate. Also, any assets that have beneficiaries on them, such as life insurance or an IRA, those assets are going to go directly to the beneficiaries and not go through probate. Or if you have a trust, some people have trusts. Anything that's titled in the name of the trust is going to go to the trust beneficiaries and not have to go through probate. So after we review all the assets, and this is the reason why we want to look at all the statements and all the accounts, we sometimes come to the conclusion that there is no need to probate the will, even though there is a will. And that could be because everything is joint or has beneficiaries. So some people do try and avoid the probate process by making sure of that they want to make sure there's nothing left in their individual name, so that they can avoid the probate process. However, if you do have to go to probate, there's different types of probate. There's something called a small estate proceeding. The small estate proceeding is if the probate assets are less than $50,000. If it's more than $50,000, then it's a full probate proceeding. The small estate proceeding, as it implies, is a simpler procedure. There's less forms to file, so it's a little bit easier than the full probate proceeding. There's different probate filing fees, and that depends on the size of your estate. So you can see it varies from a few $100 up to a little bit over $1,000. If you're a small estate, however, the filing fee is only $1. So when you're doing the probate process, it's highly recommended that you use an attorney to do this. If you're doing the small estate, that's something you probably, if you were so inclined, try and do on your own. There are forms available online. Generally, the clerk of the surrogate's court can help you out with a small estate proceeding. On the other hand, some people just don't want to be bothered with those forms and have an attorney do it. But if you're doing a full probate, it's generally advisable to use an attorney. There's different forms and procedures that have to be followed, and there's different places where it can go wrong. So one of the first things you have to do is you have to file the petition with the original will. Then you have to file a family tree. And the reason you file that family tree is to see who are your closest relatives. So if you're survived by a spouse and children, that's all you have to list. You don't have to go further out on the family tree. But if you don't have a spouse or children, then you would go to parents or to siblings or to nieces and nephews. And the reason you have to list everyone on the family tree is because the court needs to give notice to anyone who inherit property if you had died without a will. So let's say I wrote a will and I left everything to charity, but I'm married and I have 2 children. My spouse and my children would still have to get notice of the will. And the reason for that is it gives them a chance to contest the will. They can say, well, she wasn't really of sound mind when she signed the will. We're going to contest it because, we would be the people who would inherit it otherwise. So that's the whole purpose of getting the family tree identified and serving notice to all of those individuals, is so if they choose to, have a chance to contest the will. And there's a few bases that you can contest a will on. So first is if you had capacity. And there are always 2 witnesses at a will signing when you sign a will. So if someone does later on decide to say, okay, I don't think that person had capacity, the first thing that will happen is that the witnesses will get interviewed. So the witnesses are going to testify as to what they saw that day, if they think that person had capacity or not, if anything looked unusual to them. Most of the time, I'll say it is hard to fight that, but there can be cases where you bring in medical evidence and maybe that person had Alzheimer's, so they didn't know what they were doing when they signed the will. It's usually a capacity issue. Sometimes a will can be contested based on undue influence or fraud. So for example, someone who is elderly, maybe a little bit lonely, they make a friend, they get, they call it undue influence, and this friend says, I need some help, can you leave money to me? So that's basically a type of undue influence. There's more to it than that, but that the person would not have normally left it to this person if this person was not putting some pressure on them to do this. So after you get past this point, so if no one contests the will, then the will process is going to go forward and the executor who's named the will is going to be appointed. Now, there are also times when maybe you think the will is valid, but you don't approve of who the executor is, and you can try and fight that also. That's a tough battle to change who is appointed as the executor. Generally you can only object to that if that person has some kind of criminal background or a background of fraud or stealing money. So again, doesn't happen that often. So those are kind of the worst cases, but assuming the family is pretty together and no one is contesting the will, really the next step in the process is that letters testamentary will be issued to the executor. After the executor is appointed, they have all these jobs that you see here. So they have to identify and make an inventory of all of the assets of the estate. They have to start collecting the assets. So what does that mean? So what that means is for different bank accounts, you're going to close out bank accounts and put all the money that you gather into an estate account. And ideally, everything goes into the estate account. You pay off any bills or expenses or debts. You wait the requisite amount of time, which I'll talk about in a minute. And then once that time has passed and it's ready, you're ready to make distributions, you send all the beneficiaries something called a receipt and release agreement. And they sign this agreement saying that they agree to the amount that they're going to get. And then you're able to give them a check for their share of the estate. So, this is the process. It can be very simple. It can be very complicated, depending on how many assets the estate has. Generally, the main thing we see holding up estates is if there's real estate and you have to clean out the house and sell the house, because that can take a couple of months to do. The process of closing out the bank accounts is generally much simpler and doesn't take us long. So in terms of how long the estate has to be open, there's a statutory requirement that after you have been appointed as the executor, the estate has to stay open for a minimum of 7 months to allow any creditors to file their claims. So this doesn't mean that nothing can happen for those 7 months. Many times the executor has an idea of what the debts are. They pay off the debts. They don't anticipate any other debts being filed. So they could start to make partial distributions of the money. But we usually advise that you do keep some money in reserve until the end of the 7-month creditor period so that you can pay any claims that may come up. Now, the risk of distributing the money too early is that if a creditor does file a large claim and you don't have enough money to pay that claim, you'll have to go back to the beneficiaries and ask for some of that money back. So that's a risk. Again, most people don't have large creditor claims. Most people do distribute the money, sometime within that 6 to 7 month period. So that's the shortest, I should say, amount of time that an estate is open, about that 7 to 9 month period. Estates that have more complicated assets or that have real estate that they're having difficulty selling, it's not unusual to see an estate open for 1 to 2 years. The longest estates are the ones where there's litigation, over the will or the choice of the executor or the handling of the assets, and those can take many years to settle. So when you're an executor, you are going to want to know what bills that you have to pay. And as I said, the creditor has time to file a claim against the estate. So you have to pay the creditors from the assets of the estate, only up to that amount. Sometimes in smaller estates, there may not be enough money to pay all of the creditors. If that happens, as the executor, you're not required to come up with your own money to pay the bills. And sometimes because of the way the creditors do their debt collection, you may feel pressured or that you do have to pay this out of your own money. But you have to remember you only have a role here. You're the executor for the estate. You only have to use the estate money to pay the estate bills. If there's not enough money, you're going to pay everyone pro rata. You're just going to take whatever you have and split it among the different creditors. And you'll get approval from the court before you do that. So can a creditor go after non-probate assets? and they can't. So they can only go after probate assets. So if you, for example, are the beneficiary on a life insurance policy, that life insurance money does not have to be used to pay a debt of the estate. An IRA that comes to you does not have to be used to pay an estate debt. You know, same thing for anything that passes to you because it was joint with you. It's really truly only probate assets that were in that individual's name. As I said before, the family members are also not obligated to pay any of the debts unless you co-signed a loan with the person, which, you know, would not be that common. So as a relative, you do have protection from creditors. You don't have to pay out of your own money, and you do have rights to ask those creditors to stop harassing you. Claims are only against the estate. So what are some of the costs for probate and administration of estates? There's going to be the court fees that we saw. That's the fees that range up to about $1,200 or more. There'll be accounting fees. As an executor, one of your duties is to make sure that the final income tax return gets filed for the decedent. So you do have to pay for that and pay any taxes that are due. There's legal fees. There's going to be property maintenance fees. So if there's real estate involved, you have to maintain that property until the time that it's sold. You may have to have an appraisal done. And here's an example, if there's, you know, 3 children who are the beneficiaries and one of them wants to buy the family home, then you would get an appraisal done. And that one child would then use that appraisal to buy out the other 2 siblings to purchase the home. So that can happen. It just has to be done at a number that everyone agrees. As an executor, you are entitled to commissions. I would say most of the time we don't see the executor take commissions. But again, that's usually in an estate where everyone's getting along and, you know, it's the spouse or the children who are getting the money, so they don't feel the need to take a commission. However, there's cases where maybe you're not the close family member, but you're the executor, or maybe there is a lot of complications with the estate. You know, then you are entitled to take a commission, or you may want to take it in that case. The commissions are set by statute and they're a percentage of the estate. And the downside to taking a commission is that commission is subject to income tax. So you do have to pay taxes on the amount of the commission that you receive. Some other fees that are not as common are process serving fees and heir search fees. And these usually go back to a type of estate where someone is contesting the will, you know, so you have to serve them a citation, or searching for heirs. You know, maybe we don't know who the beneficiaries are, so we have to do an extensive search to find who the next of kin is. Those are not as common. So these are potential complications of estates. We've already gone over some of them. Some others we haven't gone over. Or if you have a minor or an incapacitated beneficiary, that money or their share of the money can't go to them directly. So it's either going to go to their guardian or a trustee. A trust would have to be set up for someone who's under 18, or if they're incapacitated. That can make things a little more complicated. If you have a charitable beneficiary who is receiving the balance of your estate, in that case, the New York State Attorney General's office, who represents all public charities in New York State, has to be notified, and they have to review the estate to make sure that the charity is getting their fair share, because the idea is that their job is to protect the public charities and make sure that the executor isn't spending too much money, and instead that the majority of the money is going to charity. If you have property in more than one state, so as many people do who like to spend the winter right outside New York State. If you have property in Florida or South Carolina, you would have to do a second probate in that state. So you would have one probate in New York, and that would handle your New York home and all of your assets. And then you would have to do a second probate in the state where you have your second home. So that's an added expense and complication. A way to avoid that is to have a trust for your house here and then your other home. And by having your homes owned by a trust, you're going to avoid probate in each of those states. Foreclosure proceedings, not as common, but we do see our fair share of estates where the individual had not been making the payments on the mortgage, or the mortgage may equal what the value of the property is. So that in that case, we kind of have to negotiate with the bank to decide what to do with the property. So these are reasons to avoid probate. Privacy is one. That you don't want anyone to know your affairs. And the reason is that everything that's filed with the court is public record. But if you have a trust that stays outside of probate, that's completely private. No one knows who your beneficiaries are. If you have a trust, it offers you some protection from will contests because you're not filing any paperwork in court. There's no automatic way for anyone to contest the trust as there is with a will. So it's much harder to contest who the trust beneficiaries are. It's also private. They don't have a right to see what's in the trust. Minimizing administration time. So a probate at a minimum is going to be open 7 months, takes a long time. If instead you have a trust, that the trustee has immediate access to those funds right after that person's death. So you could immediately access those funds to pay some bills, and you could distribute some assets, a month or two after that person's death. You don't have to wait that full amount of time. Also minimizes fees if you're doing a trust administration rather than a probate. It's going to be cheaper because you're not going through the court. So these are the ways to avoid probate, just to review them. So having assets that are joint, assets with beneficiaries named on them, or having a trust. And there's two types of trust. There's revocable trusts and irrevocable trusts. Both of those avoid probate. Both of those trusts have a trustee, and the trustee takes over upon the death of the individual and then starts to make distributions. Another way to avoid probate is to start making lifetime gifts of your money to get money into the name of your children or your grandchildren. So that's a way to avoid probate. It's not so good in terms of long-term care planning, which we do talk about in other webinars, but if you're gifting money, that can come back and hurt you if you need to apply for Medicaid. Okay, so we are at the end. If anyone has any questions, please feel free to unmute yourself or type in the chat box, and I'll be happy to answer your questions. Any questions, anyone? All right, well, I must have answered everyone's questions, but if you do think of a question and do you want to reach me after today, you can reach me at this email at info@herzoglaw.com or give the office a call at 518-465-7581. And I'll be happy to answer your questions. Everyone who did attend the webinar today will be receiving an email with the PDF of these slides. So you can review this information after today. You should be getting that in the next day or so. And I do see one question here before I do sign off. And let's see. Question is that your father has a home in Pennsylvania and he's been living with you for the last 2 years. How do I handle this? So I assume the question is how to handle this in a way to avoid probate. I mean, if there's a will and the father leaves the house to you, that's fine. Make sure the house gets to you, but you would have to probate in Pennsylvania to transfer ownership of that property. Instead, to avoid probate, you could do a couple of things. Your father could add you onto the deed in Pennsylvania so that it's a joint ownership. He could put the house in a trust, well, those are really the two ways to avoid probate, but either a trust or a joint ownership would make sure that that property passes to you, and it does avoid having to go through probate in another state. Okay, so this is a good question. This is a question from someone who is in an independent living complex, and it has a buy-in fee. I'm sure many of you are familiar with those. You have to pay to move into this type of a living arrangement. And the percentage of that is returned after death to your estate. Is there a way to get it transferred to a trust? That's a good question. Most of the time that money is payable to the estate, so you would have to do a probate for that. Sometimes we have been able to negotiate or talk to the assisted living or independent living facility and have that refund assigned to a trust. So then they will make that payment payable to the trust, so you don't have to go to probate. So it would be a conversation with the individual at that community to see if they're willing to enter into an assignment. Okay. Let's see. Any other questions?
Thank you.
You're welcome. Take care. Okay. Have a good afternoon, everyone. Take care.